book to this book launch. Okay, so it is a tremendous honor to have you all here for the presentation of Dilek Kurban's book. The title of the book is The Limits of Supranational Justice, the European Code of Human Rights and Turkey's Kurdish Conflict. And the book has recently been published by Cambridge University Press. Maybe Dilek, you can show the book. I don't have it on my desk.
Voilà.
Oh, there it is. There it is. Françoise Tulkens says it. And
yeah, of course.
So that's the book. Warmly recommended. Now, the book is based on the thesis that Dilek defended in 2018 at Maastricht University. So we are very proud that she chose Maastricht University and the Center for European Law at the Faculty of Law for the launch of the book. And I remember, so it's based on her thesis, and I remember how impressed, well, of course, the promoter, Bruno de Witte, and myself were, but also the jury was of the book, because this is not just an academic achievement, it's also a very powerful and a personal story, and a very moving story indeed. And the merit of the book was also recognized when Dilek won the Erasmus Dissertation Prize in 2019. And now, 1 year later, the book has thus been published by Cambridge University Press. Now, the book starts with from the premise that the effectiveness of a supranational court can best be measured on the basis of its actual impact on authoritarian regimes. And she uses Turkey's Kurdish conflict as a case study to critically assess the effectiveness of the Strasbourg court. And the book consists of two main parts. And the first part is an extremely powerful and compelling socio-legal account of the efforts of Kurdish lawyers in mobilizing the Strasbourg court on behalf of abducted, executed, tortured, and displaced civilians under emergency rule. And the second part is a doctrinal legal analysis of the case law of the Strasbourg court in these cases. And the book shows, alas, that while part of the explanation of the persistence of human rights problems in Turkey, of course, lies in indigenous political and social factors, the effectiveness of the European Code has also been impeded by the system itself, by the ECtHR system itself. And it has been so in two ways, is what Dilek states. First, the court has not made full use of its review powers in overseeing Turkey. And second, the Council of Europe members have failed to resort to available sanctioning mechanisms due to Turkey's geostrategic importance. The book is also critical, not only for the court, but also for the academic approaches to authoritarian regimes and to the ECtHR and its court. So it's for very good reasons that you are here in joining us for the book launch, because this is a book that must be read and its message needs to be discussed. So allow me first to introduce the speakers of today. Françoise Baroness Tulkens is a Belgian lawyer and an expert in criminal law and in human rights law. And she was, among many other things, a professor of the Université Catholique de Louvain. And she has published widely on human rights and criminal law. She has also received honorary doctorates from several universities, but of course she's here mainly in her capacity as a former judge of the European Code of Human Rights. She was a judge at the court between 1998 and 2012 and was elected section president in 2007, and she was vice president, became vice president in 2011. She retired from the court in 2012, and we therefore hope that she is, or we feel that she is extremely well placed to share with us her inside views from the code on the book. And then our second speaker, Rick Lawson, is a professor of European law at Leiden University, and he was dean of that faculty of law at Leiden until 2016. And he has published widely on ECHR law, on the Council of Europe, and on the protection of human rights in the EU legal order. And he will offer us a more external academic perspective and perhaps also take a broader look, not only at the court, but at the system as a whole. But first and foremost, of course, we will listen to Dilek Kurban herself. Dilek is currently a fellow and lecturer at Hertie School in Berlin. She holds a JD from Columbia Law School and a Master in International Relations, also from Columbia. But Dilek is also, and even more importantly so, the daughter of Kurdish immigrants who left their village in the late 1960s to give their children a better life, and the granddaughter of a Kurdish patriarch displaced by the military in the 1990s. But she was born and raised in Istanbul, hiding her ethnic origin and blending into the middle-class environment to which she belonged. But she always remained very much aware of the injustice brought upon the Kurds in the emergency region. Now, after her studies, she started her professional career at the UN Department of Political Affairs in New York, but then returned to Turkey. And between 2005 and 2013, she engaged in policy-oriented research at the Turkish Economic and Social Studies Foundations, lastly as the director of its democratization program. Those were other days indeed. Now, she regularly wrote columns in leading newspapers and frequently appeared in the media, and she has commented on human rights issues and the democratization process in Turkey. But then Dilek transitioned to academia in 2013 and moved to Berlin, where she decided to start writing this book that we are launching today. And the book, again, is The Limits of Supranational Justice, the European Court of Human Rights, and the Turkey's Kurdish conflict. Dilek, I now give you the floor.
Thank you very much, Monica, for this wonderful introduction. I'm very humbled. I have a PowerPoint presentation. So just if you, okay, all right. So good afternoon. I thank the Maastricht Center for European Law, in particular Professors Ellen Voss and Annalisa Volpato, for hosting this event. And of course, to Professor Monica Klaas for taking the initiative and being here to moderate it today. I also would like to thank Chantal Kuipers. I hope I'm not terribly mispronouncing Chantal's name, who's now here behind providing us technical assistance and who did the logistical preparations. It's just wonderful to be back at Maastricht Law Faculty, where, as Monica said, I defended my PhD dissertation. Under my co-promoters one was Monica and the others Bruno De Vita, who's also here with us. I'm of course also grateful to Judge Tulkens and Professor Lawson for being here, for making the time and for their interest in my work. What inspired this book was an encounter in summer of 1998. I was then a young graduate student at Columbia University. I was assisting a group of American human rights lawyers in their fact-finding mission in Turkey's Kurdish region. And I was translating their interviews with Kurdish lawyers who were engaged in criminal defense and ECHR litigation on behalf of victims of gross violations under emergency conditions. And I remember how struck I was by the resilience of these lawyers, who, first of all, themselves were victims of state violence, and yet won groundbreaking judgments at the ECHR, many of which are in every major textbook on the ECHR. Among these lawyers was Tahir Elçi, who had been arrested on dubious terrorism charges, held in incommunicado detention, during which he had been threatened with death and tortured. And this was already in the mid-90s. Tahir then became a dear colleague and friend. And on 28 November 2015, while he was the president of Diyarbakir Bar Association, Diyarbakir is the largest city in Turkey's Kurdish region, he was assassinated in circumstances implicating state responsibility. To this date, the perpetrators remain unidentified. Tragically, his killing will most likely remain unpunished and become yet another case of impunity against which he dedicated his entire professional career. The cover photo of my book was taken at his funeral, displaying generations of Kurdish lawyers whose human rights advocacy has been a source of inspiration for my work and for this book. Now, in these photos, we see an occupying military force, masked special operation teams, completely destroyed towns, and civilians carrying their few remaining belongings and fleeing into safety. And these photos were not taken in Grozny under Russian siege or in Aleppo during the civil war in Syria. They were taken in the towns of Cizre and Şırnak in Turkey's Kurdish region. In July 2015, the Turkish military launched an offensive in the Kurdish region. It went into densely populated towns with thousands of combat-ready troops and armored vehicles against urban militants of the Kurdistan Workers' Party, the PKK. The military bombed and laid siege to entire towns without any regard to the presence of civilians. From August onwards, the government declared round-the-clock, open-ended curfews in more than 30 towns and neighborhoods, which lasted several days, weeks, months, and in some cases, years. Over 1 million people were locked up without access to food supplies, water, electricity, power, and emergency health services during the long winter months. No one, including the sick, the wounded, the elderly, pregnant women, and children, was allowed to leave without authorization. Neither was anyone allowed to enter, including parliamentarians, humanitarian observers, and journalists. According to the United Nations, by the end of 2016, some 1,200 civilians had been killed by indiscriminate use of tanks and heavy artillery inside residential areas. Many of them died for lack of access to emergency health services. According to the Turkish government, over 350,000 residents were displaced. According to human rights NGOs, national and international, numerous were disappeared and tortured. Not a single military or security officer has been held accountable to this day. One of the civilians who was killed during the curfews was Taybet Inan, a 57-year-old mother of 11. On 19 December 2015, at around 7 p.m., she was shot to death outside her home by Turkish security forces. She was on her way back from visiting a neighbor across the street. Her crime, quote unquote, was to step out during a round-the-clock curfew in the Kurdish town of Silopi, where she lived. While she lay wounded in front of her doorstep, her family called for an ambulance, which never arrived. Her brother-in-law Yusuf too was shot when he stepped out to help her. The family called the emergency line once again, this time to seek authorization to bring an ambulance themselves. The authorities said they would be safe to leave if they carried white flags. The family obliged, but was nonetheless shot at. After several failed attempts, the family watched Taybet and her brother-in-law Yusuf bleed to death. The family was able to retrieve Yusuf from the courtyard into the house, but Taybet's body remained out on the street. For 1 week, her dead body lay in front of her house, while her family repeatedly begged the authorities for permission to retrieve and bury her. Once again, the family was told they could leave as long as they carried white flags. Once again, they obliged. Once again, they was shot at. This time, Taybet's husband, Halit, got injured. Luckily, he survived. One of Taybet's sons later wrote, quote, "My mother remained out on the street for a whole 7 days. None of us could sleep. Worrying dogs would come around. Birds would perch on her. As she lay 150 meters away from us, we too died," end quote. On 25 December, Taybet's body was finally taken from the street by the authorities to the morgue of the local hospital. When the authorities buried Taybet 18 days later, they allowed only 2 of her children to be present at the funeral. Her husband and remaining 9 children were denied a farewell. She was buried without a religious ceremony. Individuals trapped in the curfew zones did precisely what would be appropriate in a country that claims to be a democracy under the rule of law. They went to courts. They requested Turkey's constitutional court to issue an interim measure by ordering the government to end the curfews and to either cease the military operations altogether or at least carry them out in accordance with international legal standards. One after another, they failed. According to the Constitutional Court, there was no serious danger requiring an interim measure. The court did not even review whether the curfew decisions lacked legal basis as claimed by the applicants, let alone engage in a proportionality analysis. The ECtHR's response was not much different. Out of the 34 applications made by over 160 applicants, the ECtHR granted interim measures in only 5. In 4 of these cases, the Turkish government defied the order, resulting in the death of the applicants. In the remaining 29 cases, the ECtHR relied on the decision of the Turkish Constitutional Court, which it found, quote, to be relevant and potentially capable of providing interim relief for the applicants, end quote. Taibet's family was among the petitioners. Before applying to Strasbourg, they sought help from the Constitutional Court. Taibet's petition, the family's petition, reached the Constitutional Court on 6 January 2016 after her body was taken off the street. The family requested a very specific interim measure, the return of Taibet's body so that she could be buried by her family properly with a religious ceremony. Despite the urgency, the court did not respond. Meanwhile, the day after Taibet's family petitioned the Constitutional Court, the government amended the relevant regulation, stipulating that bodies not claimed by families within 3 days would be handed over to local authorities for burial. On 8 January, the family petitioned the ECtHR. That night, the authorities went to Taibet's family home and asked her illiterate son to sign a document, which was later found out to state that the family had until 9 a.m. the same day to claim the body, or else the authorities would bury her in a place of their own choosing. By the time the rest of the family was informed, they were too late. Taibet was buried by the authorities. The lawyers informed the ECtHR immediately and insisted on their request for an interim measure, this time to enable the family to at least hold a religious ceremony by Taibet's grave. The ECtHR rejected. On February 2nd, nearly 1 month after the filing of the petition, the Constitutional Court finally issued its decision, rejecting the request for interim measures on the grounds that Taibet had already been buried. 5 years after the filing of the individual petitions in the curfew cases, the Constitutional Court is yet to issue a judgment as to whether the Constitution and the Convention have been violated. As for the ECtHR, in January 2019, it rejected all pending cases on grounds that the applicants did not exhaust available domestic remedies, first and foremost, the constitutional complaint mechanism. So the question, of course, is how has all of this been possible, right? Because Turkey is, after all, an EU accession country since 2005, and that status suggests that Turkey has fulfilled the EU's Copenhagen political criteria, including the protection of minority rights and the rule of law. Turkey, moreover, has ratified the European Convention on Human Rights as early as 1954. Not only that, but Turkey is actually among the handful co-drafters, countries who drafted the convention. Finally, it has been subject to the ECtHR's compulsory jurisdiction since 1990. So clearly, there's a puzzle here, right? After all, the European Convention system has been declared as the world's most effective human rights regime. There's a widely shared claim that the ECtHR is the world's most effective supranational human rights court. And furthermore, the ECtHR is, of course, not new to the Kurdish conflict. It has built a sizable case law on this issue since the 1990s, finding multiple violations of the convention in hundreds of judgments concerning serious gross violations. And yet, there's been no fundamental change in Turkey's policies towards the Kurdish conflict. State violence against Kurdish civilians continues unabated, as I just described. Security forces who committed these crimes remain unpunished. Non-violent Kurdish dissent continues to be criminalized. Kurdish human rights lawyers continue to be arrested, intimidated, and jailed, and even perhaps murdered, as in the case of Tahir Elçi. Elected Kurdish officials continue to face judicial repression for contesting official policies and demanding equal treatment and cultural recognition for the Kurds. Currently, dozens of Kurdish members of parliament and mayors, elected mayors, are in prison, many of whom are being held in prolonged pretrial detention since November 2016, and even earlier in some cases. In addition, Kurdish mayors have been stripped of their elected seats and replaced by government-appointed bureaucrats. Certainly, Turkey's extremely poor human rights record derives from complex historical, political, sociological, and domestic factors, which I describe at length in my book, which I will not do today. That said, the ECtHR's share in this outcome must also be addressed, particularly in light of a vast academic literature attributing to it a positively transformative role. So this brings to my research question. Monica had alluded to that also in the beginning. The question I'm asking is, what are the possibilities and limitations of effective judicial review by a supranational human rights court of authoritarian regimes engaged in state violence against minority groups? I seek answers to this question by taking the ECtHR's engagement in Turkey's Kurdish conflict as a case study, and hope that my conclusions are generalizable for the court's engagement in other contexts such as Russia, but also for example, the Inter-American Court of Human Rights and its engagement in authoritarian regimes in the Americas. A few words maybe about effectiveness, what I mean by that. Now, my focus is the effectiveness of the ECtHR and not compliance with its judgment, its rulings. While compliance is certainly an aspect of effectiveness, theoretical scholarship I find to be too limited in its scope in defining the effectiveness of supranational adjudication as the ability to compel state compliance. Placing government's execution of judgments at the center of inquiry shifts the attention away from supranational courts, takes their rulings at face value, and thus misses the chance to meaningfully assess their effectiveness. I understand effectiveness to have two essential components. Again, I should stress that I'm speaking about authoritarian regimes, effectiveness vis-a-vis authoritarian regimes, not liberal democracies. Supranational courts' willingness to make full use of their adjudicatory tools and resources, their willingness to do their best, in other words, and their openness to legal mobilization of minorities which are failed by their own judicial systems. Both of these, I have to emphasize, are independent of supranational courts' ability to actually change government behavior, but concern their willingness to keep the pressure on authoritarian regimes by, for example, documenting state violence, exposing the complicity of domestic judiciaries, calling for real policy change, as well as by hearing the justiciable claims of minorities through being and remaining open and responsive to their legal mobilization. In sum, with respect to authoritarian regimes, I understand effective supranational adjudication as one which effectively substitutes domestic judiciaries who are complicit in state violence against minorities. Few words maybe on scholarship. As Monica said, I'm quite critical of this scholarship because, when you look at the ECtHR scholarship, you see a dichotomy between the old and the new member states. So we have the old ones, established democracies, strong rule of law traditions, which need only fine-tuning of their legal systems. And then we have newcomers, right, which are post-communist nations with fragile democracies, weak rule of law systems, and they need structural guidance. Similarly, scholars of constitutionalism in the ECtHR system also categorize member states according to two dates. They argue that the basic formula of an entrenched written constitution, a charter of rights, and constitutional judicial review was replicated in every new constitution adopted in Western Europe since 1949, and they include Turkey within Western Europe. Constitutional scholars depict the early 1990s as a second phase of constitutionalism, this time eastbound. Accordingly, the accession of Central and Eastern European countries has required the ECtHR to assume the role of a constitutional court. But it's really striking how Turkey has been treated in this scholarship. It's literally perpetually a footnote. At best, its exception is recognized, but often in a footnote or in parentheses. So evidently, there's a significant gap in scholarship. The old new member states dichotomy certainly does not capture the case of Turkey. It has been there from the beginning, as I said earlier. And yet the basic formula never applied to Turkey. When you look at the constitutions adopted after the Second World War in Turkey, there are two, but also there are a series of constitutional amendments. None of them has produced a rights-based constitutionalism. Neither has Turkey been going through a linear democratization process. Nearly 70 years after its transition to a at least three times interrupted polyarchy, it remains a country where some of the freedoms regarded to be sine qua non of democracy are selectively and subjectively adhered to. The developments since the failed coup in July 2016 make this all the more obvious. Unlike the transition to democracy from military dictatorships in Southern Europe and from totalitarianism in Central and Eastern European countries, the transition in Turkey was from an authoritarian single-party regime to polyarchy, where the system has remained anti-democratic. In other words, there's never been an identifiable rupture with the ancient regime or a decisive break with an anti-democratic past. The regime change in Southern and Central Eastern European countries was coupled with constitutional moments where new political elites drafted new constitutions, which were then given to new courts tasked with transitional mandates. So in these states, democratic transition, constitution making, and transitional justice were interwoven processes. Certainly recent developments in the poster children of post-communist transition, obviously I'm speaking about Hungary and Poland, but also seems to be Slovakia, for example, cast shadow on what seems to be premature assessments on the durability of these transitions either. But coming back to Turkey, the constitutional regime adopted by the junta after the 1980 coup has survived the transition to electoral politics and has since been preserved and expanded by all civilian governments. Today, when you look at laws governing virtually every walk of public life in Turkey, ranging from political parties to media, elections to civil society, higher education to high judicial institutions. All of them have been drafted by the junta. And notwithstanding EU-induced amendments here and there, the authoritarian spirit of these laws remains. Finally, Turkey has been governed by some state of exception during half of its republican history. Now, in seeking answers, I primarily engage with two theoretical and methodological approaches. The first is, as Monica kindly emphasized in the beginning, I resorted to socio-legal scholarship to see how Kurdish lawyers mobilize the ECtHR to bring an end to state violence and to achieve political and cultural rights for the Kurds. My book builds on the empirical data I gathered over the past 15 years through semi-structured interviews, participatory observation, dinner conversations, and collaborations. In line with the bottom-up approach of the legal mobilization literature, my focus was on Kurdish human rights lawyers. But I also interviewed Turkish government officials, British human rights lawyers, Council of Europe officials, ECtHR judges in respect of Turkey, and lawyers at the court's Turkey desk. Second, I looked at the ECtHR's responsiveness to Kurdish rights claims. For that end, I employed the doctrinal method of legal research. My primary focus was the court's jurisprudence. I analyzed not only its judgments, but also its inadmissibility decisions and strikeout rulings. I did not confine myself to majority opinions, but also studied the opinions of dissenting judges. Finally, to also assess the court's effectiveness in terms of compliance, I studied the Committee of Ministers resolutions, interim resolutions, and Turkey's legal texts and rulings of Turkish courts. So, which conclusions can be drawn regarding the European Court's oversight of state violence in the Kurdish region? Monica mentioned them in the beginning also. Now, first, the ECtHR has never made full use of its review powers, namely the tools and resources at its disposal, not even during the peak of its engagement in the Kurdish conflict, which is roughly the mid to late 1990s. Although it issued hundreds of similar judgments in nearly identical cases of torture, enforced disappearances, extrajudicial executions, and forced displacement, the ECtHR has never said that the emperor is naked, namely that the Turkish state was engaged in an organized and discriminatory violence against a part of its population, and that this violence was carried out and covered up by the entire state apparatus, including the judiciary. And this is not due to the inherent limitations of supranational review. The Inter-American Court of Human Rights has shown that it is legally possible to find a state practice of violence on the basis of one case alone, and I'm talking about the famous first judgment, Velázquez-Rodriguez versus Honduras. The ECtHR simply did not want to do that. Second, the ECtHR's reluctance to acknowledge the absence of the rule of law in Turkey became all the more pronounced with the Council of Europe's enlargement. Preoccupied with its docket crisis, the ECtHR endorsed in Turkey's impunity regime by approving a reform law which gave Kurdish victims of gross violations compensation, but not justice. Thereby, the court went against its own judgments, where it had repeatedly said that there can be no effective remedy without holding perpetrators accountable for their crimes. A final factor explaining the ECtHR's ineffectiveness is its rigid application of the subsidiarity principle, which became all the more pronounced since the failed coup, its docket concerning the Turkey's measures after the coup attempt. Over the course of its engagement for 3 decades, the court has first-hand witnessed the Turkish judiciary's complicity in covering up the gross violations against Kurdish civilians. And yet, in applying its procedural rules and substantive doctrine to these cases, the court has always acted on the assumption that Turkey is governed by the rule of law. So why does Turkey still matter? Scholars have been generous in their assessments of the effectiveness of the ECtHR system. Their positive conclusions have been possible, I argue, because they completely overlooked the Turkish case, or at best treated it as an anomaly. In reality, as Monica also said in the beginning, the effectiveness of a supranational human rights court can best be assessed on the basis of its engagement in hard cases. And I argue that in the case of the ECtHR system, Turkey is that hard case. Why is that? Long accepted and treated by the European Convention system as a liberal democracy, Turkey is in essence an authoritarian regime. Seemingly, it has been an electoral democracy since 1950. In reality, electoral competition has never been a level playing field. Certain segments of the population, first and foremost the Kurdish minority, but not just, have always been denied equal political participation, both during and between elections. Frequent political party closures, the 10% electoral threshold, and the imprisonment of elected politicians are only some of the legal strategies that the Turkish state has employed towards that end. Turkey has never adhered to the substantive sine qua non of liberal democracy, first and foremost human rights and minority protection. Its political culture has never tolerated democratic dissent, particularly on sensitive issues concerning nationhood. The judiciary has never acted independently from the executive. More importantly, it has not strived to do that. Despite their formal independence, Turkish courts have fully cooperated with authoritarianism during military and civilian rule alike. But the European Convention system itself has impeded the court's effectiveness in Turkey. And there are two principal reasons for that. One is the ECtHR's deference to Turkey's terrorism defense, counterterrorism defense. The court readily accepted Turkey's argument that gross abuses were unintended consequences of counterterrorism. Granting Turkey a very wide margin of appreciation, the court has never questioned the necessity of prolonged emergency rule in the Kurdish region, which lasted 15 years. Nor did it review the proportionality of emergency measures as one would expect from a human rights court. The second factor explaining how the convention system has impeded its own effectiveness, and now I'm talking not just about the court, but the broader system, has to do with realpolitik. Both during and after the Cold War, Turkey's geostrategic significance for Europe has insulated its domestic policies from external pressure. This, I argue, is the main reason why the Council of Europe member states have never resorted to available enforcement and sanction mechanisms against Turkey. They tolerated successive military interventions by never suspending Turkey's membership and resorted to the interstate complaint mechanism only once after the 1980 coup, only to reach a problematic settlement with the Turkish government. Furthermore, no infringement proceeding has ever been filed against Turkey for its non-execution of ECtHR judgments. Most recently, for example, its ruling calling for the immediate release of Selahattin Demirtas, a prominent Kurdish politician and former parliamentarian who remains in prison since November 2016, despite a Grand Chamber ruling of December 2020. The Turkish case has significant implications, and this is my last slide, for scholarship. Existing theories on the ECtHR's effectiveness need to be revised on the basis of empirical case studies of the court's engagement and impact in authoritarian settings. Recent developments in new member states such as Poland, Azerbaijan, Hungary, and Russia render such rethinking all the more necessary. The European Court too needs to develop a differentiated approach, I argue. In applying its evidentiary rules, such as those concerning burden of proof, interpretive tools such as margin of appreciation, and doctrines such as positive obligations, the court should be mindful of the fact that subsidiarity cannot be a fit-for-all principle in its relations with domestic judicial systems. It is only after scholars and judicial practitioners adopt such a differentiated approach that we can meaningfully assess the ECtHR's effectiveness in authoritarian regimes which engage in violence against their minorities. As much as we would all desire an ideal world where individuals can find justice at the courts of their own countries, the reality remains that millions of European citizens are still dependent on Strasbourg for justice. While the court has justified grievances about its workload, efficiency can never justify partnering with authoritarian regimes and legitimizing their repression of minorities and dissidents. Thank you.
Thank you very much, Dilek, for a very clear and powerful presentation. It's like your book. It's not only clear, it's also sobering and very critical, not only of the court, but also of academia. I will now give the floor to Judge Tulkens for her first words discussing the book, and then after that Rick Lawson will be given the floor. After the two have spoken, Dilek will briefly respond, and we will take questions from the floor. If you want to already send in your questions, you can put them on the chat, but there will also be opportunity to phrase your questions live by raising your hands. But now I will give the floor to Judge Tulkens.
Okay, thank you very much. Thank you for the invitation. It's a privilege to be here and to have the opportunity to read this excellent book. Really, it's a privilege to read it in depth. And voilà, I'm very happy to be with you to learn this book. Alors, dear Monica, you are a co-supervisor, co-promoter of this thesis. So first of all, I would like to congratulate you and the other co-promoter, because I know it's a really job to conduct a PhD thesis. And I realize that it takes time, and you did it. And so I want, if you can convey my best regard and my congratulations to the other co-promoter, because it's really important for me. Alors, as you said, I will try to concentrate from the bench. From the bench, it means that I will try to have an inside view. And Professor Lawson, who is there, and I think is better placed than me to put emphasis on the convention system as a whole, because I really both aspects are very important. In one word, it's a very courageous book. Very courageous book. And I want to say that from the very beginning. It seems to me that this book is an excellent book. It's really the perfect example of the indispensable and fruitful relationship between the European Court of Human Rights and legal doctrine, between judges and scholars. And from both sides, I think we are fulfilling our social role. And that's why it's so important. We are applying the convention on the basis of individual application. So we have to decide on a case-by-case basis. And I know that you qualify that as a futility, that we come back to that later. I'm not sure that is such a futility, but well, that's exactly what we are doing on a case-by-case basis. Whereas you as scholar, you have and you should have a general overview of the judgment of the court in order to put them in context, to scrutinize their coherence, their potential, their limits and shortcomings, because of course they are. And reliable legal commentary, as you did, draws our attention to judges, to evolution, discrepancies that are not always noticeable. We don't see that so clearly as you can do it. And we cannot see that with the same acuity when we are in the core of a case. And that's the reason why scholars and judges are indispensable allies. And I take for that, we are allies. We are allies for the maintenance and the further realization of human rights and fundamental freedom. Alors, having said that, and that's the way I read this kind of book, this critical book, which for me is very important to have this critical analysis. The scientific quality of your book is outstanding and even remarkable. And I read so many books, I have to confess, about the convention, and so many PhD theses about different aspects of the European Convention that I'm able now to make a difference. And really, your book has an outstanding and remarkable quality on a scientific point of view. You are rich of this empirical study. I really appreciate it. And also, which is very important for me, because at the court you are unable to do that. And so I accept your criticism that you explain at the end of the book. But you also put an historically contextualized qualitative research. And so both these aspects for me are really interesting. Empirical study with interview with many people, and also this qualitative research. And both for me are very important. I have to confess that I really appreciate your introduction. The introduction is a very substantial one, and this introduction is really illuminating. It's illuminating. It's very important at the beginning of the book. What are you going to do? What are the research questions? Which is the theoretical way you will address all these questions? So really your introduction is really excellent in order to give from the very beginning what you are doing to do it and in which context. So for me, it was really illuminating. And so having read that and reading the rest of your book, you are offering a substantial and unique. And I insist on that. For me, it's really a unique contribution towards clarifying what is really at stake in the Kurdish conflict. And as you said from the beginning, and you repeat it here in your oral presentation now, a few minutes ago, you gave voice to both Kurdish victims of state violence and the lawyers who seek justice. Here I have a small reserve. When you say that lawyers seek justice, justice is first of all in the country themselves. Of course, the European Court can do, but the European Court is a safety net. And it's important to put the emphasis on the fact that justice, first of all, should be in the country themselves. And when you are discussing about the effectiveness, the limits of supranational justice, do not forget to think and to put the emphasis on the fact that first of all, it is in Turkey itself that justice must be carried on. And that's for me very important. But in this respect, your professional, your intellectual journey your professional parcours, as we say, and your personal commitment is highly significant. What is really interesting is that you are at the same time in and out, I should say. You're in because you know the situation, you live in there, you are very committed to it. And at the same time, you are out and you are able to reconcile these two perspectives, in and out. Alors, on this basis, and of course, some people will say, well, she's more an activist than a scholar. No, that's not a valid criticism. It's not a valid criticism because you are able to reconcile in a position from the inside, which can be called activist, and at the same time in scientific perspective. So if later you will listen to this criticism, I am at your disposal to rebut it, okay? Alors, on the basis of the Turkey experience, you tackle, of course, a very difficult and complex topic concerning the limits of supranational justice. And you dare to put that in your title. Yes, there are limits. I am not among them who say, well, the court is the system, the best system in the world. No, it's one system among others. So I am really attached to the court, of course, and I think the court has an indispensable role to play, but it's completely naive to think that is the only tool, that is the only way. The court has possibility, has limit, and it's so important to see that in order to improve the system. And at the core of your book, and that's for me, it's very important, is this inevitable question. Is the European Court of Human Rights the most effective adjudicator of human rights in ethno-political conflicts? And my answer should be no, no, not at all. That would be a lie to say that. We cannot say that we are one tool, we are one adjudicator, but not the only one, and I cannot say that we are the most effective because of course there are limits. Other instruments have also limits. So it would be naive to think that other instruments are the best instrument in the world. It doesn't exist. There is no magical instrument in this field. There is no magical instrument. We have to use all of them. That's why complementary and synergy between all these instruments are for me so important. But in your thesis, and I do agree there with Professor Michael Korman, that your book, and I quote him, is a major addition to research on legal mobilization by subaltern, I should say vulnerable population in authoritarian regimes. And that's the side effect of your book. It's so important to take into consideration the legal mobilization by subaltern population, because that's a reality. That's a reality, and so we can take that from your book. Alors, of course, despite the fact that Turkey, you know, that it's a member state of the Council of Europe and the court in 1954, I remember we celebrate in Istanbul the 50th anniversary of the accession of Turkey to the convention. It was a celebration in Istanbul because 50th anniversary, and many people say, no, it's not impossible. Turkey is, yes, 54. Of course, I do agree that the individual application later, 1987 and so on, but Turkey's member states in 1954, and we have to take that seriously. 54, and nevertheless, and I like the expression you use, the Turkey is still a perpetual footnote. I love this expression, a perpetual footnote in scholarship. Is it true? I didn't know that. I didn't realize that. In Turkey, in other countries, I don't know. Is it a perpetual footnote? Maybe in the French literature, because I'm more familiar with that. In the English literature, I'm not sure. In the German one, do you think that's really the reality? But more than that, more than saying that it's a perpetual footnote, you demonstrate, and that's very, at the beginning, I say you observe. No, you really demonstrated. And that's important. You demonstrate deep failure in the case law of the court to end gross violation in the Kurdish region. And of course, we also, it would be naive to think that a judgment of the court will have the impact to end gross violation, but to contribute to the end, of course, at least that. And of course, it revealed the limitation of the court reach into the Kurdish conflict. And I think what is important for Turkey, for the Kurdish population, but also for all the member states, it is a warning for a world with increasingly powerful state executive and constrained society. Now we are discussing about backsliding of democracy. So we observe that in many countries, so what you are observing in Turkey is as for me, highly significant for what we are living now in different member states of the Council of Europe. Alors, which are to my mind, and then I will enter into the question you put forward, which are the main obstacles, the main hurdles for supranational courts to effectively review authoritarian regimes? Because at the end of the day, that's really an important aspect of your thesis. An authoritarian regime engaged in the physical and political repression on minorities in the context of ethno-political conflict. And as you said, and Monica repeated that in his presentation, Turkish-Kurdish conflict is a case study. It's an excellent, sorry to say that, but it's an excellent case study. Alors you developed the question of activity. I will not go in depth in that because for me it's a very important concept, but I take for granted or I accept your two-dimensional effectiveness. Even if your book, maybe you can develop that in depth, because what do you mean by effectivity? There is a literature on that. Effectivity and is the contrary ineffectivity. So I accept what you express, exhaustive, no, not exhaustiveness. In the book you are discussing, but now today, this afternoon, we are talking about willingness. Willingness to use all the materials, all the tools we have. And that's very important. And that when you're expressing that, I say that happens very often, that we do not use all the tools we have. Why? Why? That's very important to draw attention of judges to that. We have many tools, but judges should have the audacity, l'audace, or the courage to use all these tools. And that's not always the case, I accept. And then you say the two aspects of effectivity is willingness to use, okay, and responsiveness. Responsiveness to the mobilization. Maybe we are doing more, but the other aspect, the willingness to use, I'm not sure. Alors, you have chosen 4 types of state violence, and you're right. Extrajudicial execution and for disappearances, torture and for displacement. And what I like also very much is that you say that concerning the Turkish situation, there are different cycles. And in the line of the ligne du temps, when we saw that, of course, that I can realize. I was at the beginning, and now I see that I left the court in 2012. So I know the situation has changed. So I know better the beginning of the first cycle, I should say. Alors, which are for me the main hurdle? I agree with you with many of them. Interim measure, forget about that. Interim measure, for me, that's not the main point. That's not the main point. I will not discuss that here, but no. Establishing the facts, you put that. Yes, the denial policy obliges a court to act as a first instance court. That I realize in many cases, we are obliged to act as a first instance court, which is really problematic for us because it's not our task, not at all. But what I do agree with you, and that maybe I am also culpable of not having done that, but there was a real reluctance to use Article 14. There was a real reluctance, that I observed that, because it was very often during the deliberation, without entering into the secret of deliberation, I can say that, but very often it was a discussion about Article 14. Why don't we go into Article 14, and especially because it was such a systematic situation after so many years, and I realized how reluctant the court, the chamber and the grand chamber were reluctant to use Article 14. And I think that's a characteristic of a general approach to discrimination claims made by minority. And now, after so many years, I think it's very, very important to try to develop this article. Is there? That's exactly the good example. We have a tool. Why don't we use it? And maybe I didn't realize that as well. That's why I like your book, because now I am no more in the court. But if I were in the court, I will use your advice, of course. Alors, another aspect which are very important. You say the court is judging individual and not people. Okay. So we disregard history and politics. That's true. Unfortunately, that's true. Why? It's really difficult. Of course, we're official argument because we cannot transgress the boundaries of judicial review. That's an official argument. I don't think it's the main important one. And it's true that we never pass judgment on the core issue, systematic and discriminatory state. Sometimes I was wondering whether some university or bar, or I don't know, why don't we have more third-party intervention, drawing our attention to that? Of course, it's the responsibility of the national judge, it's the responsibility of the other judge, of the registry, but third-party intervention could be very helpful in this regard to put precisely the case within its context, because that I realized that we didn't do that. We didn't do that or not enough, because we did it sometimes, but not enough. Not enough for many reasons. And so, alors, you also pinpoint the futility of the case-by-case approach. I accept that we have a case-to-case approach. And of course, the result of that, the corollary of that is that there are sometimes inconsistency and incoherence. To avoid case-by-case approach would be very, very difficult, I think so, because we are judging in concreto and not in abstracto. That's the reason, that's the rationale behind case-by-case approach. And that maybe you could have discussed more, because the case-by-case approach is that because in order not to be frontally against sovereignty, we are examining a violation of the convention in a situation, and we are judging in concreto and not in abstracto. We are not judging the system in itself, but you are judging a case in a concrete situation. So there is some reasons and there is some rationale on the case-by-case approach. I will not defend it absolutely, but I think there is some reason. That's maybe you go a little bit too quick on that. And I can accept that this case-by-case approach can result in some inconsistency and error. That's why doctrine is so important. In many cases, the court, I realized that some professor or doctrine and so on opened my eyes to a question. I say, my God, of course it's that. Of course. And so it opens my eyes. And in a case, when I have another case, I was able to say, no, we have to change that. Alors, more political. Well, rigidity in the evidentiary rule, of course, that I fully agree. The court cannot continue to stick to this rigidity in the burden of proof. We have to accept the reversal of the burden, and we did it now. The circumstantial evidence, that's more technical, but I think there is no firm reluctance to that. That's quite easy. It's not quite easy, enfin, never is easy, but we can accept it. Alors, when you say that the court is an obstacle to its effectiveness because we treat Turkey as a liberal democracy, page 300. Yes, that's true. That's true. That's true. We treat Turkey as a liberal democracy, not as an electoral democracy. Maybe too often. That's why we need to, the court must have more information coming from the outside, third party. The court should rely on other source of inspiration. That's very important. And hard cases in an authoritarian regime are very, very important. Obsession by the docket crisis. I fully agree with you. During the 14 years I was in the court, I was at the end really frustrated. We discussed all the time about the docket crisis. For me, it was, to be honest, completely inadequate. And even now, nobody is listening to me, I hope, but even false. Even false is not the real problem. It's not the real problem. When I was at university, we had too many students. Now at the court, we have too many cases. A system has always too many. So I am not impressed by this argument. And there was an obsession by the docket crisis. That's absolutely sure. That's absolutely sure. And all the energy of the court was to try to deal with this docket crisis. 95% of the cases are inadmissible at the court. Don't forget that. So, you know that better than me. Alors, the most important point today for me is subsidiarity. Subsidiarity for me, and I am happy that you raised this issue. Subsidiarity goes too far. I fully agree with you, because the risk is that the court is becoming a rubber stamp. And in Turkey, the whole of the Constitutional Court is absolutely, it's too much. I will not enter into a new discussion about the headscarf, but when I dissented Leila Shaheen, I was irritated by the fact that the only truth was the Constitutional Court. So I will not mix the two problems because they are completely different. But the court risk, and the court is becoming a rubber stamp of the. Alors, of course, it's okay because the human rights should be and have to be improved in the country. But if the country is not democratic anymore, what are we going to do? Shall we continue to put the emphasis on subsidiarity? That's becoming now today a very, very important problem. And I read so many articles about subsidiarity saying that's the solution. Today, the situation is completely different in Hungary, in Poland. What are we going to do with country where democracy is not at the agenda? So subsidiarity should be completely reappraised today. And it's not a magical stick, no more, not at all. So I'm really happy that you, and that's exactly what happened in 2019, when the court declared inadmissible so many cases against Turkey, because the Constitutional Court have said that and that. That's a good example, which is absolutely, for me, unacceptable. So margin of appreciation, subsidiarity, thanks God, Protocol 15, which is intending to put subsidiarity in the preamble, is not yet in force. So maybe we can wait, we will see. But of course, that's really a problem. Voilà. I will stop here because I think, oh la la, I am too long. Sorry, you asked me to do. Well, my personal conclusion is at the risk of being against the mainstream. I continue to be convinced that human rights are the last rampart against any abuse of power. And his unique role must be preserved at any cost in a democratic society. But I accept your invitation. When in your book, in your seminal book, because I think it's a seminal book, your book is of great intellectual honesty, which for me is the most important quality of a scholar, is the intellectual honesty. And you put an invitation, and I quote you, for a reappraisal of current academic and jurisprudent approaches to authoritarian regimes. That's exactly, I accept the invitation. Voilà, thank you very much. Sorry for being too long. You should have interrupted me, Monica.
No, there was no reason to interrupt, because I think I've very much enjoyed your discussion.
Sorry.
My question to Dilek now is, Dilek, would you like to respond now, or do we first take the discussion by Rick?
No, I think we should continue.
Okay. Okay, so then I will now pass the floor to Rick Lawson. Rick.
Thank you, Monica. Judge Tulkens, that was wonderful. And if there's no time left for me to talk, I accept it was worthwhile listening to you. You gave a wonderful laudatio. Monica, friends, thank you for the invitation. I think I should start with a disclosure here. You mentioned that the Erasmus Prize was awarded to Dilek's book in 2019. I was a member of the jury at the time, so I'm biased. I don't read the book as any neutral new reader. I read it at the time when it was defended as a PhD thesis, and already I was impressed. I will make another confession just to be absolutely transparent. I was still a member of the same jury last year when another dissertation from Maastricht was awarded the prize, and again from the promoters Monica Klaas and Bruno de Witte. I mention this for all the listeners and viewers, and now you will understand why I was invited for this event. I'm a big fan of the Maastricht School of Law and the work of the two PhD supervisors. When in the jury, we received Dilek's book together with many other books that were nominated by their faculties, because the book had been nominated by Maastricht Law School. Our initial reaction was, ouch. This is a harsh book. It is confrontational. It is an uneasy read, in a way, an uneasy truth. Judge Tulkens used this marvelous word, courageous. It's a courageous book. Beware, if a British speaker would have said courageous, it might have had a very different meaning, but it was, in a way, an uneasy book to read. Still, we were convinced by it, by its qualities. It was compelling, both in the penetrating analysis of the situation on the ground in Turkey, how people turned to Strasbourg, trying to involve the court and seek protection, and being disappointed by the court. That was a compelling story. But also, and this was important for the jury, the book has a much wider significance than just the situation in Turkey and how the court responded. It is a much wider discussion on how the court interacts or should interact with authoritarian regimes. And we felt that the book deserved a wide readership, deserved to be read. Of course, Dilek was not the first one to ask for attention for this issue. In 1994, Menno Kamminga, who at the time was still in Rotterdam, but would also be appointed professor at Maastricht. Menno Kamminga wrote an article in 1994, is the European Convention on Human Rights sufficiently equipped to deal with gross and systemic human rights violations, Netherlands Quarterly of Human Rights? And his analysis was, no, actually the court is not in a position to play a meaningful role when things really get rough. In essence, he said, and others have said it before him, Christian Tomuschat at the time, and others after him, the court has been wonderful when it comes to micromanaging countries which are democracies abiding by the rule of law, but which suffer from, let's say, minor problems, incidents. But when the going gets tough, when there is an armed conflict, when there are gross or systematic violations of human rights, the court is not as effective or doesn't have the impact that one would hope it has. This debate, of course, was triggered at the time by the situation in northern Cyprus, where the conflict was not being solved. The situation in Turkey as well, after the right of individual petition had finally been recognized by Turkey. There were these cases of Aksoy and Aktivar and Mentesh, where Aydin, where very serious violations of the convention were found, and where NGOs were reporting that there was a widespread use of torture. And there was a call whether Turkey should remain in the Council of Europe or not. So this triggered academic debate, at least academic, not so much political debate. This seemed somehow to disappear from the radar in the years that followed. I suppose that around the turn of the century, there was mainly the euphoria that the Berlin Wall had fallen, that the divide of Europe had ended, and that the Council of Europe was able to expand. There was this mood of optimism. The permanent court in Strasbourg was established, functioning on a more professional basis. So in a way, the attention shifted away from the problems identified in the mid-1990s by Kamminga and others. I do recall in those days that the Parliamentary Assembly organized a conference with the theme areas where the European Convention of Human Rights does not apply. What they meant in earnest was where the convention cannot be enforced. Of course, the convention did apply, but somehow it didn't deliver. And what the Parliamentary Assembly had in mind were mainly the frozen conflicts, Transnistria, South Ossetia, where people lived in very dire circumstances, but were not benefiting from the protection of the court. Many reasons, and one might be that the whole system in Strasbourg is based on this perhaps rather naive idea that if there is a problem in any of the participating states, individuals will complain about their problems, will turn to the court, will toll the alarm bell, but perhaps in these most difficult areas that Europe has, individuals are not aware of the fact that they can go to Strasbourg. If they are aware, they don't have the means to do so, they don't have legal assistance, or they don't dare to use the avenues that in theory they have at their disposal. So there was an awareness, at least with the Parliamentary Assembly, that not everything was perfect, but I think it was only until much more recently, since in several Central European countries, we saw this backsliding emerging, Hungary, Poland, that the issue in a way was back on the agenda. And from that perspective, Dilek's book is a very timely contribution to the debate. Is the court responding? Yes and no. I think in recent days and years, we see some changes. We see that Article 18 of the Convention has been rediscovered, where in essence, the court says that authorities have acted in bad faith. And we have seen a number of judgments, including the Navalny case, or I should say, one of the several Navalny cases, where the court, Grand Chamber, found a violation of Article 18 on the part of the Russian authorities, a number of cases involving Azerbaijan, and actually also Turkey, Georgia, countries in this region have been found in breach of Article 18. It might illustrate a rekindled conscience on the part of the court that in these countries with authoritarian tendencies, one should look beyond appearances and try and identify the real meaning behind limitations imposed on the rights of individuals. So this is one sign of a change. Another sign of the change is the discussion, which apparently takes place in Strasbourg. And I'm an outsider, I'm an academic, so hard for me to tell, but apparently a discussion is taking place about the priorities in dealing with cases. For a long time, there's been a frustration that the court was completely absent in the debate about the rule of law in Hungary and Poland, especially Poland. No Polish cases in the Strasbourg court. They were brought before the Luxembourg court, but not in Strasbourg. A number of reasons must be there. But in March, the court announced that the Turkish cases dealing with the rule of law and the independence of judiciary will now be treated on a priority basis, which I think reflects an awareness on the part of the court that structural issues are to be addressed by it. So hopefully the court has woken up and rises to the challenge. At the same time, I think it would be wrong to only look at the court and expect that the court on its own is able to solve issues if there's so much pressure and so many political sensitivities behind these cases. A crucial role is there for the Committee of Ministers, which brings together the representatives of the Council of Europe member states, and which has a function to supervise execution of the court's judgments. Rightly so, it is a common responsibility of the member states that each one of them complies with each of the judgments of the European Court of Human Rights, which they accepted as final and binding. And it is up to the member states to supervise execution and to put pressure, if necessary, on states if they fail to execute the judgments. And I think it would be unfair to the court if we were only to look at the court and would not take into account the activities or lack of activities within the Committee of Ministers. This is not to criticize the book of Dilek, because she does pay attention to the role of the member states, but I think it is crucial if member states allow fellow states to get away with very severe judgments of the European Court of Human Rights, where the most crucial and basic human rights have been found to have been breached. And if states realize that they can continue to be a member of the Council of Europe without complying with these judgments, the authority, the legitimacy of the court will disappear very rapidly. And I can imagine very well that the judges are aware of this. And if they don't feel the unconditional support of the Committee of Ministers and the member states, it is only natural that they become more cautious and ask themselves, what if we are radical in our decisions, but there is no follow-up? What will happen then? What will this mean for the entire system? I think I should like to end here. Already so much has been said, we should open the floor for discussion, but I would like to add with one quote, which sadly has become a favorite of mine in recent years. It's a quote from Sir Winston Churchill at the University of Zurich in 1946. The speech is well known because it was a call for European unity, and it is an important speech for that. But in the speech, Winston Churchill also reflects on the period behind him, the period between the two great wars, and he reflected on the failure of the League of Nations to prevent the Second World War. And I can't help repeating what he said at the time. The League of Nations did not fail because of its principles or conceptions. It failed because these principles were deserted by those states that brought it into being. It failed because the governments of those days feared to face the facts and act while time remained. And I think that that message of 1946 is still extremely relevant today, and Dilek's book is a vivid illustration of that. Thank you.
Okay, thank you so much also to Rick Lawson and to Françoise Tulkens for their comments on Dilek's books, first comments to open the discussion. But I will first give Dilek the floor to respond. Before I do so, I would like to ask those of you who are able to do so to start their cameras. So, because it's always nicer when having a discussion that we see each other. So if you are able to open your camera, then make yourself known, which makes for a much more lively discussion. Thank you so much for doing so. Okay, Dilek, you have the floor, and you can I mean, there is so much comment. There was a lot of praise, some comments and some questions. You can pick and choose where you want to begin and where you want to continue the discussion. In the meantime, people can either put their questions in the chat or simply raise their hands, and then you will be given the floor. But first, Dilek.
Thank you very much, Monica. I'll really keep this brief in the interest of time because we have so many participants here, and I would very much like to have this to be a discussion. I can only thank really very much with the bottom of my heart to Judge Tulkens and Professor Lawson for their kind words about my work. It's just fantastic. And Judge Tulkens, you really did. Thank you for taking up on the invitation, as you said, and sort of really engaging with the idea of whether or not the ECtHR has made full use of its tools and resources. And it's fantastic to have the insider's perspective on that, for example, concerning Article 14. So I guess maybe I'll just make a couple of comments and then just and leave it there. One concerns responsiveness to legal mobilization. You know, I did not, in this presentation, I not speak about that at all, you know, the whole legal mobilization part, although, as I said, that was really why I wrote the book in a way. That was the inspiration. And I wonder whether that's true. And I think that sort of is one, well, what I mean is, I mean, I discuss this at length in the book, as you know, but for example, just to give an example from, also I mentioned in my presentation, this, the court's application of pilot judgment, in my opinion, very premature and problematic application of pilot judgment to Kurdish cases. It's a decision which has gone unnoticed again in scholarship, even on pilot judgment, which is really a small scholarship in a way. But actually, the court issued its second ever pilot judgment in a case against Turkey, Doğan versus Turkey, and retroactively actually called it a pilot judgment even. But what the court there did really is, by applying that, Turkey adopted a reform law. It was also, to make it increase its chances for accession with the EU, which gives compensation to, but just compensation to victims of gross violations. But there's no justice, right? The law doesn't allow for identification and prosecution of perpetrators. And what the ECtHR did really there was to prematurely declare this to be an effective domestic remedy and dismiss 1,500 cases, pending cases at one brush. And that, for example, is what I mean by being increasingly close to Kurdish legal mobilization, because what it did then, since then even more, basically the court in a way effectively closed the door that it had opened with the Aktivar judgment that Rick mentioned in 1996. So that's the kind of example that I have in mind, because when the court does that, when it sort of allows, Turkey to adopt these, domestic remedies, which are not effective at all, and then sort of dismiss these cases, then that closes the door in a way effectively to a large extent. And just one word on Article 14 and 18. As you rightly said, the court was very reluctant to use Article 14. Also Article 18 back then too, in the 90s, also the Kurdish cases, applicants were raising this. And here maybe I would, to a certain extent, perhaps differ with Professor Lawson on the new emerging jurisprudence on Article 18. Yes, the court issued 2 judgments so far. One is a Grand Chamber judgment on the basis of Article 18, finding Turkey to have violated. But just today, they a judgment came concerning 2 journalists. One of them is Ahmed Altan, who's been in jail for 4 years. And if there's one person, one journalist that really, really angers Erdogan and is a matter of like personal grudge, that's him, Ahmed Altan. That case is like classic Article 18 case. And the court didn't find a violation. And I would invite everyone to read this fantastic dissent written by the Lithuanian judge. I mean, what he said, this is his words, he said the judgment not finding Article 18 violation justifies repression. So and that goes also for the Committee of Ministers. You're absolutely right, it's really important. But to wait so long to bring the first and only ever infringement proceeding to Azerbaijan, important of course, but for only one dissident, and you have, in Turkey, you have in the thousands, not just the Kurds, of course, thousands of dissidents are in jail. So it's sort of, and that comes back to the realpolitik. But I think I'll just end it there, just so that we have an open discussion together. And thank you again very, very much. I'm really grateful to both of you.
Okay, then I'm simply going to ask Professor Lawson or Judge Tulkens whether they want to respond now or whether we continue with opening the floor. Opening the floor? Okay, so then I'll open the floor for questions. I see one hand raised, so you can raise your hand or put your questions on the chat. I will give the floor to Denise.
Thank you very much. Thank you very much for this organization and this excellent presentation and comments. Actually, mine isn't a question, but it is rather a comment, because I was working in the Turkish parliament during these curfews, and unfortunately I witnessed all these process. And I think, unfortunately, I don't have the opportunity to have access to the book, as all the libraries are closed due to the pandemic, and I'm looking forward to reading it. But my point is, of course, in the same time, I really don't want to drag this audience to a kind of legal nihilism, but according to my observations, Turkey declared curfews without declaring state of emergency. I think from the very beginning, it was a kind of declaration of the will of not willing to comply with human rights law. So I think this brings us to, we can say, the paradox of human rights, but the state-dependent character of human rights and the question of recognition of human rights by the state. So I think in these mass violations, mass human rights violations, the state simply don't want to comply with all the human rights regimes. So in this case, supranational mechanisms or international human rights mechanisms can naturally be insufficient. So I think, first of all, we need to address this question and then assess the effectivity of human rights regimes. And I think this point brings us to another question, the question of reparation. Taking into account that Helin Öncü, she was in Cizre, she's alive due to the interim measure of the European Court of Human Rights. Thanks for it. But still, 6 years later, a decision which declares that these rights had been violated cannot be the best reparation, in my opinion. So these are my remarks. Thank you very much for this organization again.
Okay, thank you. Who would you like to respond to your question? Is it a question to Dilek or to Judge Tulkens or Professor Lawson, or all three of them?
Actually, it was not a question. I mean, I just made, I think, 2 remarks, so that was it. Thank you.
Okay. Judge Tulkens, did you want to intervene? Then could you unmute?
Was it?
Okay. Judge Tulkens, if you could unmute yourself.
So is it okay so?
Yes.
Voilà.
Yes.
Dilek, maybe you can say something about the state of emergency.
Absolutely, Deniz Hanım, thank you very much for that. Indeed,
Think about that in your book. Oui.
You know, I mean, it is. I sort of mentioned it in passing in the beginning. The applicants raised this issue with both the Turkish Constitutional Court and the ECtHR, that the curfews lack legal basis, and that's what they were basically. That was the base of the argument. Indeed, Turkish law requires state of emergency to be declared for, to take, for such extraordinary measures to be adopted, and the Turkish authorities did not do that. So that the legality of these measures were, first of all, of course, a major problem, which both the Turkish Constitutional Court and the ECtHR evaded to respond. I mean, arguably, one could argue that the reason why, and I don't know, maybe Deniz Hanım would have insider's perspective on that, Turkey didn't want to do that was because it's still an EU accession country. It just doesn't look good, to declare state of emergency. State of emergency in the Kurdish region was abolished under EU pressure in 2002, right? 15 years after it was inserted in 1987. But of course, the fact that it was not based on state of emergency, that these measures were adopted, then raises serious questions of legality indeed.
I'm just, at this question for me, it's interesting because of exactly the same problem now in Belgium, because there is a judgment of the Tribunal of First Instance saying that all the measures who have been taken lack legal basis. Because there was no state of emergency, there was no, but now it's an appeal, so the judgment is not final, not yet final, but voilà.
Yeah, no, I mean, it's true. I mean, the court didn't.
And what about the derogation in 2016? Turkey asked for derogation, huh?
They did, but it was Judge Tulkens. You see, the state violence in the Kurdish region, the state, the curfews, they were imposed in summer of 2015. This was a year before the coup attempt. Yeah, and that's maybe arguably how it escaped attention in a way. That was at the time when EU was engaging in this breaking this refugee deal with Turkey. So they sort of, that was the understanding in Turkey is that in the human rights circles is that was sort of like the unspoken term in a way of that deal that that EU would not make much of a deal. And then next summer, as you said, there was a coup attempt. Then Turkey declared state of emergency and derogated. So everything it has done since then, these purges, prolonged pretrial detentions, were based on that. But in the case of the Kurdish conflict, both these curfews and the initiation of prolonged detentions, pretrial detentions, started already before. It's just that then the government used the emergency paradigm to sort of, in a way, quote unquote, finish the business and arrest Kurdish parliamentarians, for example. They were arrested then, but their immunities were already lifted, for example, before the coup attempt. So the preparation was underway in a way.
Thank you very much.
Monica?
Yes.
Could I say something about the second issue that Denise raised, which is reparations, individual reparations? Clearly, and then I realize that I'm speaking in the faculty of Theo van Boven, who was the champion of arguing for reparations for human rights violations. It's obvious that reparations and to restore justice are extremely important for individual victims of human rights violations. This is beyond discussion. However, and this is maybe where our nice consensus of this afternoon will end a little bit, let me raise the question to what extent we can expect from the European Court of Human Rights to achieve individual justice in a case that involves so many individuals as we now see in Turkey. If we think of the thousands, tens of thousands who have been dismissed, who have been imprisoned, what is it that we expect the European Court of Human Rights to do in each of these individual cases? Do we expect the court to decide in each of these individual cases if somebody was dismissed as a police officer in a provincial town in the north of Turkey for good reasons or not? Whether there was in a specific case a tie with this alleged movement that was behind the attempted coup or not? Let me play the devil's advocate and say you cannot expect the European Court of Human Rights as a sort of industrial tribunal or a labor court to examine the facts of each case, quite apart from the fact whether the European Convention of Human Rights guarantees the right to work or the right to a particular job, etc. What I think you could expect the European Court of Human Rights to do is to put pressure with all the means it has at its disposal to Turkey, in this example, and make sure that it has the house in order and that it creates effective remedies. And then these remedies should provide individual justice, rather than that the court takes it upon its own shoulders to do that. I don't think the court can do this for logistical reasons, for legal reasons. It doesn't have the evidence, it cannot call witnesses, it doesn't have the capacity. So rather, it should push countries like Turkey, and not just Turkey, the problem is much wider, to create effective remedies. Then the question, of course, is, did the European Court of Human Rights do this? Did it use all the instruments at its disposal? The answer is probably no. Did it get all the support it needed from the Committee of Ministers and the other political organs of the Council of Europe and the EU? Answer is certainly no. I'm in agreement with that. But when it comes to our expectations of the European Court in individual cases, I fully understand that individuals who have lost everything, who have seen their lives destroyed, turn to the European Court and ask for protection of their rights. But I wonder whether the European Court, at the end of the day, is the institution that can deliver this. Over to you, Dilek, because you will disagree.
I will. Thank you. And also allows me to get back to Rick, what you've said about priority policy. I mean, maybe just to start from, just to go back to that, maybe, you know, the priority, let's take Selahattin Demirtas. You know, he's a former parliamentarian. He was also the co-chair of the Kurdish party, who ran for, you know, like the formidable, like a formidable rival to President Erdogan. He was arrested. He was held in pretrial detention in November 2016. He petitioned the Turkish Constitutional Court right away, and then he petitioned also the ECtHR in February 2017. May 2017 is when the ECtHR revised its priority policy and included among the first category of urgent cases, cases of individuals whose who are deprived of their liberty, right, including Mr. Demirtas. And yet the chamber judgment in his case was issued 21 months after he applied. And that means 17 months after the priority policy was put in place. And the grand chamber judgment 46 months after he applied. So the question, and he was one of only 12 MPs who applied, whose cases were actually first joined by the ECtHR, communicated together to the Turkish government, and yet later separated, we don't know why, and the court handpicked Demirtas and only issued this judgment in his case. All the others who are in jail still since November 2016 don't even have a chamber judgment. There is no explanation for this. And that's the kind of example that I mean by tools and resources. If you have a priority policy, that's a tool, use it, but use it effectively, right? Today I mentioned Ahmed Altan, again, he's a journalist. He was one of 10 journalists who, again, petitioned together. His case was exactly the same, factually, legally, with his brother. I'm not going to go into detail. In his brother's case, the judgment came a few years before. Ahmed Altan only now. Meanwhile, there are other several journalists who still haven't had a judgment. Again, priority policy. And I think now to go back to what Ricky just said in terms of, can we expect from ECtHR? I mean, yes and no. I mean, I understand, of course, the basis of the question, but that's why I'm saying that we have to make a difference between authoritarian regimes and liberal democracies. Let me first start from, okay, what happens if we say no, if we agree, if we take your position, which I know that it's a reluctant position, it's, because of circumstances, what happens then? That means that we are basically saying effectively that millions of citizens in Europe, not just in Turkey, let's see what's going to happen to, for example, LGBT community in Poland, that the millions of individuals will not get any justice because we know they will not get justice domestically. And in terms of effective remedies, you said, ECtHR should push Turkey to introduce domestic remedies. What I'm saying, and I'm just showing with my book, I believe, is that it should not do that precisely because of the way it's doing it. Because what the ECtHR has done is actually has become an obstacle to Kurdish legal mobilization. It just made things much worse, by finding, for example, not just this compensation mechanism, but for example, a similar mechanism that Turkey established for Cyprus cases, a similar administrative mechanism Turkey established for prolonged, non-execution of court rulings, and of course, the constitutional complaint mechanism. The problem is this: authoritarian regimes like Turkey, they understand the terms of the game in a way. And Turkey it introduced all of these, certainly the constitutional complaint mechanism, because it knew that it would, first of all, bring down the number of applications, prolong the time that one needs to apply even to Strasbourg, let alone get a judgment, and of course, score a point with the EU. But you see, the problem is that it's also linked to the EU accession process. All of these accession countries were given the same homework, constitutional complaint mechanism, irrespective of whether their domestic human rights, domestic judicial systems are effective or not. In the end, the ECtHR made things much worse in Turkey. It would have been maybe perhaps preferably better had it not pushed for effective remedies. You see, it was so, as Professor Tulkens also said, so obsessed with docket crisis that it just didn't see what it was doing. And it still doesn't do it. I mean, today's judgment, I think, is an example of that it doesn't find Article 18 violation. The dissenting judge quoted Bob Dylan, how many times more. It was fantastic. I mean, you have to really read it, but it's true. What else does it need? Anyway.
Okay, we're going to leave this discussion and then I will pass the floor to Femi. Yes, you have the floor.
Hello, I'm Levent and I have a bachelor's degree in law from Kadir University in Istanbul, and right now I'm doing my LLM in Maastricht University. I have a question of clarification for Judge Tulkens, if I may, Tulkens. During your speech, you have mentioned that the ECtHR looks at cases in a case-by-case basis, of course, and this way it has to be an ally to academics because the academics have a more overview, while the ECtHR is, again, case-by-case. But that also reminds me of cases such as Opus, where the ECtHR basically pointed out a systemic violation, a systemic issue in a country. So could we please have a bit of a clarification on your argument on this specific case, on the case-by-case nature of the ECtHR?
Could you unmute yourself, Judge Tulkens?
Excuse me, the case you are referring to is Opus.
Yes, okay. That's just an example though to show that.
Okay. I see what you mean. Well, there is no contradiction. It's a new, how should I say that? The original philosophy of the court is a case-by-case approach. And what I said a few minutes ago, that's because we are judging in concreto. And this aspect is very, very, very important. Very important. It means that we cannot judge a system in itself. We cannot judge the system in itself. We can only, so in abstracto, we can only judge the alleged violation of one of the provisions of the convention in a specific case. Having said that, it's not contradictory to say that in some situations there are systemic violations. So it means, and for instance, violence against women. There are violence against women because that's the situation in Opus. It's Opus, it was exactly that. in some situations, and in other cases as well, for instance, a case against Poland, we can say that this situation repeats itself very often. Repeat itself. Alors, is it a structural or a systemic violation? It was a discussion at the court in semantic discussion. Is it structural or systemic? Structural means that is related to the system in itself. For instance, preventive detention. Preventive detention, that's a structural violation because it's related to the system itself. Here, a systemic violation means that's a repetitive violation. Alors, I know that the semantic is not, for my humble opinion, very, very clear. But anyway, so in some situations, we say that there are many of them. And that's why at once we decided that in one of these situations, it's better to have a pilot judgment. But in this situation, in the violence against women, I don't think we enter yet into a pilot judgment procedure. And I think it's better because when there is a pilot judgment, the other cases are frozen. So it's not for the applicants, it's a problem. So it's not contradictory for me. No, it's not contradictory. The red line is to say that we cannot enter, but maybe I'm wrong saying that because that's the traditional discussion, that we cannot enter into a judgment, a theoretical judgment about the system itself, because that would run against the sovereignty of the state. We have to show, and in many cases, I think it's for the court itself, it's a good limit. It's an important limit, because we are not there to say that abortion in Poland is no. We have to say that if we cannot have abortion in Poland in such a situation, and this is the case where I don't remember the name of the case, in this situation, there is a problem. So, voila. But I do agree that in some situations, it's another topic. In fact, it's not another topic. But the fact, Dilek, the fact that Turkey today withdraw from the Istanbul Convention, just having your opinion about that. In 2 minutes. I don't want to but now you are a colleague, so.
Well, if you're asking my opinion for this role, first of all, thank you very much for the clarification. And as for Istanbul Convention, I think we will get back into that as a country one day. Maybe it won't be this year, it won't be next year, maybe it will be 5 years later. But to be fair, as a Jean Monnet scholar as well, who is sent to Europe to build capacity for Turkey so that we can access into the EU easier, more smoothly. I was kind of stumped when I heard that we have left Istanbul Convention myself. So I'm not quite happy about that by principle and by legal means, because I didn't really like the arguments that was put out against the convention. But my opinion is, in the future, especially if we are very into this accession into the EU, we shall be back into the convention in a few years.
Okay,
thank you for raising the question.
Thank you.
Then I will continue with, Dilek, you wanted to intervene.
No, if there are questions, then I'll come later.
Okay, so there is a question from the audience that I will read. Does the trend of court decisions on Turkey demonstrate the soft bigotry of low expectations? And what is meant is this, that is, since Turkey is not a Western country, it is judged by different standards, and it simply isn't expected to be compliant in the same way as Western states. So it goes to the double standards.
Yeah.
Questions. And the question is to all three speakers. So who wants to go first?
I will just start.
Yes.
Problem of double standard, I've heard that from 1998, because with the new court in 1998, it was just, we discussed that ad nauseam. It was a question of double standard between the Eastern country and so on and so on. I do hope that we didn't do it. I do hope, even I think there is one case, I don't remember the name of this case, sorry, because after, when I left the court almost 10 years ago, sometimes I forgot the name of the cases. Rick, do you remember the case against Hungary concerning the police a policeman who was member of a trade union.
Rick Venier?
Oui, voilà, Rick Venier, exactement. Oh, bravo, you know, that's a good score. Bravo, bravo, bravo. Well done, c'est génial. C'est génial, Rick Venier. Eh bien, Rick Venier, that was maybe there a question of double standard. It could well be, but in general, maybe I'm wrong, but what do you think? Because I was in Rick Venier and I was a little bit frustrated, or just in difficulty, because was it not a double standard? Prohibiting member of Hungary to be member of the trade union. That was only for Hungary and not for other countries. And so I was not sure. But in general, no, we cannot accept double standard. To accept double standard, that is really the beginning of the end. So no, but okay, that's a statement of principle. But maybe this statement is contradicted by the reality. Maybe Rick could maybe tell me that we did it, but because I heard that so many times, and you know, we had a case concerning the situation of prison in Russia. And then the representative of the Russian government say, if you think that the condition of this prison over there, and the name of the case that I remember, because for Russia, it's not a joke, but it's a reality. The case was called Kalashnikov against Russia. And in Kalashnikov against Russia, the representative of the government said, well, if you think that there is a problem in this prison, all the prisons in Russia are in the same condition. So you have to make another standard for prison in Russia. And the court said, no, you accede to the convention, you have to do anything in order to accept and to obey to all the provision of the convention. So no. So I say no, but maybe, but I was very sensitive to this question, very sensitive, because it could have been a problem, yes.
Shall I go next?
Maybe you can continue.
Judge Tulkens, I think you can sleep safely tonight. You did very well in your term of office. No double standards. There are many sides to this question. One is maybe a psychological side. I heard our colleague Levent mentioning that as a Jamonet scholar, he was sent to Europe. You were not sent to Europe. You were already in Europe when you got your scholarship.
You are true. Sorry, I meant the EU.
No. But I do recall a long time ago when we could still travel. If I came in a country like Georgia or Armenia, I would be welcomed as a guest from Europe. And for me, this was always so strange because I felt I never left Europe. But this is also a psychology that people believe that perhaps they live in a country which is placed in the second tier of countries, which I think this idea we should fight. There are so many cases involving, for instance, Turkey, that it's quite easy to pick and choose and to say, well, there you go, this is clearly an example of double standards, or give counter examples. The case of Saldus, case about the right to a fair trial and access to a lawyer upon police arrest. It happened to be a Turkish case. It was crucial for the Netherlands, for the United Kingdom, for France. So are these different standards? No doubt, if you search, you will find examples where the court applied a somewhat different approach, but I don't think that there is a deliberate policy behind it. No. What is the case is that the nature of the complaints will vary from country to country. And as a result, the way in which the court responds to these cases may be colored by the circumstances. And I can also understand, and this was in Regveni, the Hungarian case, or in Vajnai, another Hungarian case, where countries emerge from a communist past. There may be sensitivities in these new democracies, which are very difficult to apprehend if you live in a well-established democracy or country which regards itself as a well-established democracy. I love to come back to the issue of choosing priorities, but first I think we should ask Dilek to reflect on these double standards.
Dilek.
I feel so conflicted because time is running out. We have other fights, but just briefly maybe think one issue, I think it goes back to the courts. It's just, you know, it's a puzzle for me. This is the international institution that should know, that knows Turkey the best. It's really well placed. It has an institutional memory, certainly the registrar. And yet it just strikes me that every time, almost in every case, that's what I mean by case-by-case approach, Judge Tulkens. It's as if it's tabula rasa, court starts from scratch, right? And one example that I want to give in that is, and on the Committee of Ministers for, well, I'll leave that, Rick, maybe later we can discuss that. But the thing, you know, going back to context, right? The court, there is a reluctance to read these cases, these violations, in the context in which they occur. So for example, several weeks before the Grand Chamber issued this seminal judgment in the Demirtaş case, finding Article 18, first Grand Chamber Article 18 violation against Turkey, several weeks before that, a chamber dismissed the party which Demirtaş belongs, the party whose from whose, you know, dozens of mayors and parliamentarians have been stripped of their elected office. They brought a case under Article 3 of Protocol 1. That decision was dismissed. I find that striking. The court, the chamber, you know, cites few precedents where they said, well, if the association members are if the fundamental rights of association members are violated, then the association lacks standing, or vice versa. Here's a political party, which, by the way, is not the first, which represents a tradition where 5 other political parties were dissolved by the Turkish Constitutional Court, 4 of which won a judgment from the ECtHR, whose mayors and parliamentarians are systemic policy, stripped of their elementary state, and the court dismisses that. It's just, so where is the coherence here? Because, you know, when we saw the Grand Chamber judgment, you know, it was applauded by saying, oh, finally we have a contextual judgment. But again, I'm saying, well, maybe let's not rush too much. How do you explain this? And that, I want to take this opportunity, if I may, to ask a question to Judge Tulkens. So there's another inadmissibility. My book, as you know, is mostly about state violence, but I also look at political rights and cultural rights.
Yeah.
In 2006, a mayor in Diyarbakir, he was dismissed from his elected office, and the entire municipal council was dissolved only because they took a democratic decision to give municipal services also in Kurdish, in addition to Turkish. Minister of Interior, AKP dominated, they brought a case, and he was dismissed from his job. He and the municipal council brought a case to the ECtHR under Article 3 of Protocol 1, also freedom of expression, you know, and the chamber dismissed that application. And I saw that actually you were in the chamber. And do you remember the case? So
No.
Again, you know, going back to context,
No.
can you, because I know the court is very sort of on electoral rights, but I mean, and it's interesting because he also was prosecuted, not just that, he was prosecuted, and AKP appointed a bureaucrat to his position. Turkish law requires repetition of elections in 6 months. That person sat on that elected position for 2 years in violation of Turkish law. Now, all of this was in the petition. And why did you dismiss that case? And why didn't you, for example, see that as yet another strategy to disenfranchise the Kurds? Because all of this is part of the same strategy.
It was dismissed on which ground? The case you are just referring to?
Abdullah Demirbaş and others versus Turkey. Abdullah Demirbaş.
If you write the name of the case, I will have a look.
Okay.
Yeah.
I can send it to you. Abdullah
I don't remember, to be honest, I don't remember, yes. But do you think that the Grand Chamber is playing its role in order to avoid incoherence or inconsistency? I don't know in this case, but generally, in order to avoid incoherence on inconsistency, because of course the court is very, it's important for the court to avoid that. And so there are some inner system. All the cases are seen by the registrar of the different chamber. There is by the Juris Consult as well. And then on a pure institutional aspect, the case can be either relinquished or it can be a referral to the Grand Chamber in order to avoid inconsistency or incoherence. Just in order to know if all these institutional means in order to avoid that do they play their role? Are they effective or not? Because I realize that the case you are referring to, I don't remember at all. I'm sorry. But if you can write the name of the case, I will have a look and I will answer by writing. That for sure, I promise you. But
yes, this may be something for a later discussion among the two of you. Maybe,
yeah. We not send that all. No, but
maybe the fact that all countries need to be kept to the same standards may lead to a differentiated treatment of countries also, right? And I think that this is what Dilek is referring to. But
yeah.
I will leave that discussion, and I will give the floor. That we have two more questions, and I will ask them, ask the people to ask their questions. We will collect them, and then we will take them two by two. And I hope that they're not too different. So Jochem de Hoop, and then Lilian Soerdi. Jochem, you go first.
Yes, thank you. Thank you for the great discussion. I did have a question. So maybe for Dilek. So do you think that the ECtHR could be an effective tool to assess Turkish military action in northeast Syria? So for their action against the YPG, the Syrian Kurds. Of course, your research was focused on the Kurdish region in Turkey, but do you think it can also assess the situation in Syria?
Okay, and then Lilian.
Thank you, Monica, and thank you, Dilek, for an excellent presentation. Now I look forward even more to reading your book. I wanted to ask you to reflect a bit on your positionality, and Françoise Tulkens already alluded to that. So I wanted to hear some more thoughts on how you, and this must have been, it's challenging for everyone dealing with human rights issues, but even more for you. I wanted to ask you to share some reflections on how you organized, especially the empirical part of the study, and the analysis then of the data, the selection of the participants for the semi-structured interviews. Thank you.
I mean, very quickly to Jochem's question. I mean, in terms of the course jurisprudence, I guess one could make an argument that Turkey is in effective control. The Turkish military is in effective control in parts of northern Syria. In terms of an effective tool, again, I mean, going back to effectiveness, authoritarian regimes rarely change. I think our expectations should not be compliance, right? Or change of behavior. That really almost never happens. The question is really to expose and to keep pressure, right? So that at least to deprive these authoritarian regimes from the argument that they are everything that is legal, of course, and legitimate as approved by the supranational courts, human rights. Do you see what I mean? Not to sort of, as the Lithuanian judge Kurish, I think is his name, said today, not to legitimize at least. I think that's really important. And what they also serve such judgments is that they bring attention. That was the achievement of the ECtHR in the 1990s until the early 2000s, is that it brought attention, international attention, to the plight of civilians in Turkey. That's why these cases, our judgments, are important. They also set precedent for other countries. So I'm no way dismissing what they're doing, I mean, this is just very briefly. To Lilian's question, Lilian, so nice to finally see you. We've corresponded so much. Positionality, I mean, is it because you're asking that because of Monica, what Monica said in the beginning, that I'm, Kurdish, is that what she meant in terms of, or that's what I understand?
That's an additional factor in your case, but there is this consideration every time for a researcher and their own convictions when dealing with human rights issues, but also, yes, given the fact that you also are a member of the minority that you're studying.
Yeah. I mean, it actually goes back to, I'm so glad that Judge Tulkens also mentioned that. I find it interesting, that this question is always often asked to members of minority or disadvantaged groups scholars but not necessarily to the members of majority. You see, because then, every Turkish scholar should also face that question in terms of, are they, impartial or not? And again, it's also when you look at, I mean, feminist legal theory, who wrote it? Women, of course, or, or civil rights movement is, of course, you know, sort of, because it is first, of course, you care more about, you know the context better, you have the insider's perspective, right? And also you kind of see that, well, you have to do it because the members of majority are not going to do that, right? Or not doing it well, you think. And in terms of, I mean, it was certainly how I did it. As I said, you know, I have been, part of my work, as part of my work in this think tank, it was very multifaceted, my engagement. You know, I studied them, the lawyers, but we also partnered together in projects. You know, we did a lot of projects with lawyers and bar associations. And I read them, I listened to them, they were friends, they are my friends, still colleagues. So I think I understand them well, I think, you know. And in terms of just the methodology, you know, I mean, I also did field work specifically on internal displacement during that era, and I interviewed dozens of government officials and victims and human rights lawyers. At the time, the institute I worked was very reputable, and they had very good relations with the government because we were supporting their reforms. So we had access. We had never had any problem I never had any problem getting an interview with a government official at the time. Now it's, of course, almost impossible. And in terms of the lawyers, you know, I mean, it's sort of snowball, isn't it? But it's also, you also handpick, in a sense, you know, if you're, for example, working on a certain, I basically approach lawyers who litigated in ECtHR and won these judgments, but I also, you know, sort of historical research, and actually I ended up reaching individuals, lawyers that I didn't even know existed, the Kurdish, first generation Kurdish human rights lawyers who are completely forgotten. So it's kind of a bit of both, yeah.
Okay, thank you so much. Judge Tulkens, would you like to come to her help? Because this is what you promised in the beginning. Now, I see that there is other question, at least there's one more question, but I'm going to, in light of the time, end the session and thank the speakers. However, what I will do, I will thank them a bit more. What we will do is we will keep the Zoom open, like in real life, you know, when people can stay in the room and have a little chats among themselves, we will do that. But I will now officially end the session thanking our speakers, Judge Tulkens and Rick Lawson, for giving their comments and engaging with the author. And then, of course, to Dilek. Dilek, you have written a wonderful book. It's, as I said, it's a must read. And to all of you, I would like to recommend you to read the book and engage with it. It's thought-provoking, and it's, in fact, it's a must read for all of you. So thank you so much for all of you to join this session, and have a lovely afternoon. Bye-bye. And for those who still want to stay, and maybe ask a question also in private, you're free to stay for a couple, I don't know how long.